Hello and thanks for joining us in Project Justice this week. I am Utobel Moran. The National Industrial Court was established in 1976 with powers over matters of trade dispute and industrial matters. However, it was not until the third alteration to the 1999 Constitution that the court assumed the status of a court of record with appeals on its decision going straight to the Court of Appeal. Now, if you have suffered any injustice in the workplace, unfair labor treatment, or even the big ones, government policies that threaten the socio-economic well-being of you as a citizen, then this episode is for you. Meet my guest, the President of the National Industrial Court, Justice Babatunde Adejumo. But that's after this news break.
An Abuja High Court has sentenced to 32 policemen who killed 6 traders in 2005. The court, however, acquitted the other 4 policemen on the grounds that the case against them was not proved beyond reasonable doubt. Justice Ishaq Bello held that the 2 policemen were convicted based on their confessional statement. He, however, expressed displeasure with the shoddy investigation carried out by the police. The Supreme Court has nullified the nomination of Christian Abag, who is holding the PDP ticket for the Okpohu, Ado, and Ogbadibo Federal Constituency of Benue State. The Apex Court also ordered the Independent National Electoral Commission (INEC) to immediately withdraw the certificate of return issued to Abba on the ground that he did not merit it and be given to Hassan Saleh, being the qualified candidate to fly the PDP flag for the 2015 national election. The Court of Appeal had earlier nullified the decision of the Federal High Court by Justice Adeniyi Ademola, which upheld the candidature of Abba. The Federal High Court in Abuja has warned the Independent National Electoral Commission (INEC) against taking any step in the disputed Akwa Ibom Northeast senatorial election case. The warning was issued by Justice Nnamdi Dingbia following reports that INEC had issued a certificate of return to one of the contenders to the seat, Basi Etim. The court warned that any such action on the matter will be an insult to its authority, as a motion for stay of execution of the judgment which INEC is relying upon is currently before Justice Riemann of the Uyo Federal High Court. The Judicial Commission of Inquiry, set up by the Rivers State government to look into the mayhem, violence and killings that took place during the December 10, 2016 rerun and supplementary election in the state, has submitted this report. Chairman of the 7-member committee, Justice Chinwendu Nwogu, on Monday presented the report, counting all memoranda received, the record of the proceedings containing the oral evidence given before the commission, exhibits presented as well, the main reports based on the evidence received. A ruling by an Abuja Federal High Court on the 2 applications filed by Ajib Exploration and Shell in the Malabu oil deal has been stalled, following fresh application from both parties in the suit. Malabu Oil and Gas Limited is seeking to be joined as a party in the suit, and it is opposed by Shell and Ajib on the grounds that it is to arrest the ruling of the court. Both parties had earlier sought the order of the court to discharge the order of forfeiture granted the EFCC over an alleged $1.1 billion Malabu oil scam. The case is adjourned to 17th March for ruling.
How would you evaluate how the judiciary is responding to the demands from the public for accountability, probity, and transparency in its operations?
The Nigerian judiciary has been accountable, but from the public's perception, they're asking for more accountability. And I think to answer your question, the judiciary has been responding. We have a body, which is our regulatory body. It's the highest policy-making body, that is the National Judicial Council, which controls all matters concerning the judiciary and administers disciplinary measures on them. The council has been doing its best. Where there is any case of complaint against any judge, the council has been handling those matters without any fear or favor, ill will or affection. And recently you could see that some judges have been shown the way out because of their involvement in one issue or the other. But when you want to talk about the issue of accountability and public perception, depends on who is talking. Because for every matter before the court, we have either 2 parties or multi-city of parties. appearing before the court. And to the winning side or sides, justice has been done. Oh, the judiciary is accountable, is fine. To the losing side, oh, the judiciary is not a good place. Depends on who is talking and what is talking all about. But all we know, the judiciary is doing its best, and we believe that in any democratic setup, what is key is obedience to the rule of law. Without that, you cannot be talking of having an accountable judiciary or having a stable or nascent democracy.
How does the court manage the workload and at the same time the demand for speedy dispensation of justice?
Well, you see, you have to balance the workload of the court. Every court has its own heavy dockets, every court. But how you manage it depends on your expertise, on how your readiness to work, and the facilities made available. People are demanding for speedy dispensation of justice. I can say in this court we've been trying about that. Some of the cases transferred to us from other courts of superior record, which have been there for 10 years, 8 years, 15 years. Within 1 year, 1.5 years, we've been delivering judgment on this. Depends on how serious the judicial officers were. And this depends on how the head of court can manage his court, by saying that nobody does things that would lead to laziness, and where there are problems, he attends to them. I think we are trying our best, and we continue to try.
The Fourth Alteration Act to the 1999 Constitution upgraded the powers of the National Industrial Court to a court of record. How has the court since then responded to the new powers it has been given and the strength it has been provided by the Constitution?
I think it is the third alteration.
The Third Alteration
Act to the 1999 Constitution amended that gave the court its powers and jurisdiction, particularly Section 254C. The court has been responding because many cases that were being handled by other courts of superior court are now being handled by this court. And unlike before, the court could handle cases but may not have the power to make orders, to grant injunctions and make orders that are prerogative from such a. But these days, I mean, by the third alteration also, anything the High Court has the power to do within its jurisdiction, the National Industrial Court has similar power to do same.
That means appeals from this court goes directly to the Court of Appeal.
Yeah, appeal from this court any appeal from this court goes directly to the Court of Appeal, and ends there, except on criminal matters or any other thing.
Are there criminal matters within the jurisdiction of the
Yes, we have criminal matters. Any criminal matter arising from the civil jurisdiction. For instance, when you are talking of strike, they are legitimate or lawful strike, they are unlawful strike. Under the Trade Disputes Act, under the Labour Act, some matters, some issues are being criminalized. So if you commit them, the court has the jurisdiction to entertain such matters. But it must be within this, arising from the civil jurisdiction of the court.
Let us also find out the jurisdiction of the court in matters involving, say, security agencies. We heard recently of a number of officers in the Nigerian military or the Nigerian police who have been fired. Does the Nigerian Industrial Court have the jurisdiction to deal with such cases?
Yes, if it is firing of his employment, not commission of any court-martial related matters, that, they've been dismissed, they've been retired, they've been suspended, they've been terminated. We have been having such cases, a lot of them, and we've been delivering judgments on this type of cases. There was a case about 3,000 soldiers who were dismissed, and they came to court. We were able to settle the matter, and at least more than 95% of them were being recalled. Because our jurisdiction is not limited to what is happening between the parties before the court alone. We consider the consequential effect on the larger society. If soldiers are terminated and it's not resolved, we all know what may be the consequential effect on the security of the nation.
Tell us about your rules and practice direction, and is there similarity between it and what is obtainable at the Federal High Court and State Court?
When I came on board about 14 years ago, the rule that was being invoked then was not quite helpful. So in 2007, in 2006 we came out with the 2006 National Industrial Code Act. So it became necessary for us to have a rule that will help us. In 2007 we came out with the rules, National Industrial Code Rules 2007. But when the third alteration came into being, now we discovered that a lot of jurisdictions have been given, more contentious issues are being handled. And we just have to come out with the rules. We now have the National Industrial Code Civil Procedure Rules 2017, which covers every aspect of proceedings and processes before the court. And that has been quite helpful. It's just like that of the High Court, but we have a specialized jurisdiction. We have taken those specializations into consideration. And we tried as much as possible to make rules that will govern every aspect of foreseeable issues that may come up before the court. So it's quite helpful.
You've talked about a strike that is lawful and unlawful. When is an industrial action like a strike unlawful, and when is it lawful?
Well, the Trade Unions Act and the Labour Act and the Trade Disputes Act, they made provision, particularly the Trade Disputes Act, made copious rules, regulations, and provisions were made for when a trade union can call its members out on strike. And for instance, if you are a management of a trade union and you have a matter that's of interest or of right, and you are not satisfied in the interest of your members, and you have negotiated with your employers and maybe there is no result, the law has not forbidden going on strike totally. No, it's a right of workers to go on strike under the ILO Convention. But before you proceed on a strike that will be lawful, one, it must be democratized. You have to see that the majority members of your union are in support of the union. Two, you must have given notice. Three, you must see that what we are fighting for is something of interest or right, that your right is affected, not something that is not within, that does not affect you directly. So when you do this, and then when you do all this, you have given notice, you have democratized it, then you can proceed. If there is no response, the law does not say you cannot go on strike. But once you fail in the chains of events, then it becomes an unlawful crime. Secondly, if you belong to the essential services, the Trade Disputes Act has criminalized that people who belong to the essential services. Who are these people? Those who, that if they down tool, it will affect directly or indirectly the lives of the citizenry or lead to breakdown of law and order, insecurity. They are forbidden from going in to strike. And that such people, if they go, it becomes an unlawful strike. Then a strike may be lawful ab initio, that is from the beginning it's a lawful strike, but in the execution of that strike, it has now been hijacked or it has gone out of the scope of what is intended to achieve. If you are going on a lawful strike and you start looting shops, you start beating up people, forcing people, it becomes an unlawful strike.
How then do you respond to criticism by some section of the public that such laws or the application of such laws tends to circumscribe the right of unions or labor groups to protest and demand for better welfare for their members?
Well, it's a debatable issue and it's jurisprudential. We have employers, we have employees, and the workplace. The right of the employer vis-a-vis that of the employees have to be balanced. If the employer is not ready to continue with business, the employees will not have anything to do. They are partners in progress. As much as the law recognizes the right to go on strike, it also recognizes the right to put them on notice and to ensure that the intent of that is not to destroy. the workplace. Because if you are going on strike and it becomes an unlawful strike and maybe the workplace is burned down, generations yet unborn may suffer for it. So it's a question of balancing. What are the issues? How can we resolve these issues without creating any bad blood? And that's why Section 20 of National Industrial Code Act says that in any matter before the court should encourage and facilitate amicable settlement. Don't forget that it is not the employees alone that may be forbidden from. The employers can also be forbidden from locking out, because the opposite of strike is lockout. You don't just lock out your workers when they are ready to work. It is you that is not making work available and for an unjustifiable reason. Yes, there are some circumstances where you can lock out workers if you know, if you do not lock out, it may lead to damage or irreparable loss on the establishment. But all this must be done within the ambit of the national law as well as international conventions as enacted by the ILO, which Nigeria has domesticated by virtue of Section 254C sub 2 of the 1999 Constitution, which says that the national law have the power and jurisdiction to entertain and apply any treaty, convention, or protocol that Nigeria had ratified, notwithstanding anything contained in the Constitution. Because Section 12 says that any convention, protocol, or treaty that Nigeria has ratified but not domesticated into our law cannot have a force of law. But by virtue of Section 254C sub 2, I think those ILO conventions, which are about 33 of them, which are part of the sources of our jurisdiction.
You see, watching Project Justice. Our guest is the Honorable President of the National Industrial Court, Justice Babatunde Adejumo. We'll take a short break now. We'll be back. Please stay with us.
Now, some decisions of the National Industrial Court has been quite controversial. In early 2016, for instance, the Industrial Court restrained organized labor from embarking on a nationwide shutdown of the nation's economy, a move that resulted in wide condemnation and called into question the right of workers to protest and demand a better deal of government. Project Justice also took up this issue with the president of the court.
There are people who have suggested that the National Industrial Court, especially when it comes to political, industrial disputes that are national in nature and have wide ramifications on the peace and stability of the country, that the National Industrial Court has sometimes have been seen to take decisions which some would interpret it in the context of being a political decision. How do you respond to such claims?
Well, the court is established to ensure industrial harmony, which will engender economic growth and stability in the country. If the threats were allowed to be carried out, Nigeria may not come out of it for months or for years. Now, some people, we say marketplaces should be shut down and nobody should move. People should stockpile food in their houses. Somebody who earns a daily bread, who works on a daily basis and they pay him, he buys things he wants to eat on a daily. He has not to go to work. He has to stockpile food in his houses and their houses. How can they do this? It is not possible. Those few people who have food in their houses, those who don't have food in their houses may now go and attacking them. In order to collect, the stronger will attack the weaker ones. 3, economically, those who are selling, the banks are asked not to work. Those who are selling petty and getting small money and are not accessible to go to bank, armed robbers will visit them in their houses and either kill them or maim them in order to collect the money from them. Now that is one. Two, internationally, it will affect us. We have bilateral or multilateral relationship with other countries. We supply them things, we get things from them, we transfer money to them, we do a sort of business activities with them. If all these are not allowed, we cannot come under international to say necessity, doctrine of necessity. No. Any problem you can solve within your municipal law, and you fail to do that, it will not affect me in my own country where I don't have any problem. When you consider the community of things together, you now see that there is need to stop it and to find a way of settling the matter. After all, after war, there is always a roundtable conference to settle the outcome of the war.
You talked about the existence of ADR, and there's been so much advocacy for litigants to try the ADR mechanism. If that advocacy takes center stage, would that have any effect on the strength of the National Industrial Court?
Yes, it will have a positive effect on the trend of the National Industrial Court. Because a case that's supposed to last for 1 year, with all the cost, risk being acquisitioned by the parties, is settled within 21 days. Is that not fine enough? I'll give you an example. There was a case that a huge sum of money, about 1 billion naira, was being contested by the terminated employees. And we sent it to the ADR Center. And within 1 week, it was settled that about 750 million naira was paid. This case ordinarily would have lingered on for about a year or two before we can get to the witnesses and all the rest. I think it has boosted the power of the court. Now, it makes people to be more friendly. It reduces the stress on the court itself, reduces the stress on the litigants as well as their counsel. And it has helped in bringing the fostered unity we are all asking for.
What effect will that have in the wider economy, especially when we talk of foreign investors coming into the country and they know that there's a mechanism for easy resolution of industrial and economic disputes?
In their countries, they have this similar procedure. It encourages them demand to come, to come, because when they invest their multi-million, billion dollar and they come into the country, they know that dispute between the employer and the employee is a recurrent issue. It must happen from time to time. It's only the way, the mechanism that is considered. Once they know that, oh, there's industrial court or labor court, whatever it is called, and there's ADR centers where they can settle, they have more confidence in their investment and in the country that, oh, they have a very civilized and modern way of settling disputes, which will not bring bad blood and we should still see them. Because employee and employer, they are all working in the interest of the, of the workplace. I think it's a good thing, and I think people are buying into it.
Does that require further expansion of the court? Because recently we understand that the court had opened a center in Port Harcourt in Rivers State. That's a major industrial hub in Nigeria.
Yes, well, thank God we're having a new court there. The state government is building that court. As federal government is building courts, the state government now, some of them now think they too should partner so as to bring justice to the doorstep of their people. Now, you are talking of the ADR, maybe it is bringing additional cost or whatever on the court. Now, we have our existing courts in about 26 states. It is within these court premises that the provisions are being made for the center. And we have these centers in 4 big zones, in the 6 zones: the northeast, northwest, north central, southwest, southeast, and south-south. So, and we have courts in all these places. So the officers are ready. They may travel to the component states within the zone to settle matters, not to reduce the cost of the stakeholders. I think it's working. And we have trained a lot of at least more than 40 of them in the U.S.
Thank you very much for your time. Thank you.
Pleasure talking to you.
Well, access to justice is a key essential in the principle of administration of justice. The judiciary has been experiencing funding challenges in recent years with a dwindling budget. However, for the industrial court to be accessible, especially at a time of deepening economic crisis and attendant industrial issues such as workers' layoff and the rest of it, it must be easily accessible. The Chief Registrar of the court explains just what they're doing to make that possible.
Well, the ordinary man on the street, if he's employed and he has issues with his employer and he needs to come to our court, the court is in existence throughout the country. We have 26 divisions of the court that are functional. In states that we don't have divisions of the court, we have registries. And in these registries, you can go and file your case there. And even if the court is not sitting in that registry, because they are sitting in the divisions where the courts sit are like within an hour's drive from where the registries are established. It doesn't take long for you to reach where you can have your case heard by a judge and decisions reached within the shortest possible time.
How will you rate the court so far?
The court is responding creditably well to the avalanche of cases that are coming before it.
Well, that's Project Justice this week. Be sure to send in your thoughts through any of our social media platforms. On behalf of the entire production crew, I am Utubao Moran. Thank you so much for staying with us.